talk more about this, we want to bring in Matt Murphy. He was a senior deputy district attorney in Orange County and spent 21 years assigned to the sexual assault and homicide units. Matt, thanks for joining us on this.
Happy to be here.
I want to start with the mistrial of Daryl Dirty Dick Smith this week. The jury was comprised of 10 men and 2 women. Let's listen to what the California Coalition for Women's Prisoners said happened during jury selection.
The initial jury pool was pretty evenly split. During selection, potential jurors were asked whether they or someone that they're close to have ever experienced sexual assault. So this question effectively disqualified many women. And rather than recognizing this type of lived experience as a source of expertise and insight, the court treated it as bias, sidelining, in our opinion, those most capable of understanding the trauma.
So, Matt, this is interesting. Courtney Hansen, they're saying this effectively disqualified many women. There were only 2 women on that jury. Matt, is that a normal request? Was this the right request in this case?
Well, that's a standard question in every case involving sexual abuse. And it is usually followed up by the next question, which is, would that experience impact potentially your ability to be fair to both sides in this case? And it is standard. And believe it or not, this is counterintuitive, Natasha, but anybody who's actually prosecuted or defended this type of case, oftentimes men are better prosecution jurors, believe it or not. Women can be very tough on other women. It always depends on the juror, but the fact that there were 10 men and 2 women on this panel, really, believe it or not, is not a huge cause of concern, I think, for anybody that's involved in that.
So if you were prosecuting a man accused of rape, you would prefer that there were more men on that jury?
I have prosecuted many, many cases in rape, both stranger rape and also acquaintance or date rape scenarios. And look, sexual abuse is so ubiquitous in our culture, pretty much around the world.
Mm-hmm.
I've had panels, Natasha, where the judge, when they ask that question, and again, that is a standard question, where every single hand will go up in the box, the men and the women, because almost everybody has either been a victim of sexual abuse by themselves or
and
somebody
isn't that
close
the
to them
problem, right? The
been.
National Sexual Violence Resource Center says 1 in 5 women are raped. It's horrifying, such an issue in this country.
It's horrifying, but also, listen, it is a hugely underreported and underappreciated statistic. A tremendous amount of men were sexually abused as children as well, or have people, their mothers, their sisters, or women in their lives that were also sexually abused. So this crosses gender lines, and I do disagree with that woman's comments that nobody has a right to quote unquote expertise that may bias a jury. I was a prosecutor for many years. Now I do defense work. I don't defend sex crimes, but look, a criminal defendant, their right to a fair jury is sacrosanct in our system of justice, and you don't accomplish fairness by keeping people on who exhibit a bias. Based on my review of this case, I don't think this judge did anything wrong.
Okay, I appreciate that perspective. The lack of DNA evidence is particularly interesting. One of Smith's alleged victims told us he used to tell her, "You'll never get me for this reason." Let's listen to her describe it.
And he leaned back on the chair and put his feet up and said, "You're a convicted felon. I'm a federal officer. Who do you think they're going to believe? You don't have a word that I can't use on air." But in other words, so the audience can understand me, it would mean ejaculate. So people can understand what I'm talking about is you don't have my physical evidence in your hands or on your clothing. So you can't, there's no way I'm going to get prosecuted.
Yeah, so she says he used to literally taunt her with that. So, Matt, in the absence of this DNA evidence, do you feel the prosecution will struggle to find a conviction at this retrial in September?
Well, one of the interesting things is we don't know what the count was, at least in none of the material that I found. This could have been 11-1 for guilt, could have been 11-1 for not guilty. We just don't know. But look, I believe there are 12 different women that testified in this case. There are certainly many more available to testify, and they're going to re-rack a panel and they're going to retry this thing, and it'll rise or fall based on the strength of the evidence. I don't, this is one of those things that happens in these cases. they can be tough. We call it the CSI effect from the TV show CSI. Jurors are so used to DNA evidence, going back to the Monica Lewinsky thing and OJ, and even before that, it is something that people expect. And a lot of very experienced defense lawyers will hammer on that. They'll pound on the idea on any missing forensic evidence because jurors are so familiar with that as a concept now. But look, 12 complaining victims is a lot. Now, the whole problem here is it's a vulnerable population because they, in fact, are convicted felons. Every one of them is a convicted felon, and that's why they're serving custody time. There's also this pending, partially pending, but largely settled civil suit. $116 million is a lot of money.
And I'm so glad you bring this up. I'm so glad you bring this up. So, we should say again, Smith still maintaining his innocence in all of this. But we see his defense painting the women as unreliable. And as you just said, they are convicted felons who started coming forward with allegations, they say, hoping for a financial windfall. Matt, this case hinges on the testimonies. Is there precedence here? Is there automatically doubt for testimonies from convicted felons because of their past?
Well, as a fundamental proposition in any sexual assault case, a jury is instructed that they're entitled to believe any witness for what the witness testifies to without any corroboration. When you have 12 different women under the California Penal Code, it's called 1108 evidence. That's essentially Me Too evidence where somebody else that's been sexually abused is able to come in and testify. So this is what's known as cross corroboration. However, it is an issue, and the defense is entitled to go into what got them in there. And a lot of these women are in there for theft and fraud type offenses that the jury's instructed they're allowed to consider that in determining their credibility. And of course, the defense will naturally argue, look, she's in here for defrauding somebody out of $60,000. What's she willing to do to get a piece of $116 million? And that's something that, that can be a very persuasive argument. But look, at the end of the day, Natasha, in my experience, juries really want to do the right thing. And I think that the U.S. Attorney's Office here will dust off their wounds. They'll reassess this thing, and they'll proceed forward in September, and we'll see what happens. I mean, 12 corroborating witnesses is a lot. And also, there's so much here between the warden and other people. It's not just a single accusation against this one individual. And the nickname is unbelievable, Dirty Dick. Imagine going down in history with that as being your moniker. But
no kidding.
They've got a lot of evidence to work with here. I think they've got a no-nonsense judge. And I would not be at all surprised. Again, you pointed it out. He's presumed innocent until proven guilty. But there's a lot more than just smoke here.
Matt Murphy, appreciate it as always. Thank you so much.
My pleasure.
Thanks for watching. Go to joinnn.com to find News Nation on your screen. And don't forget to click the red subscribe button below to get more of News Nation's fact-driven, unbiased coverage.